Honorable Health Minister of Delhi, the Honorable Satyendra Jain, Vice Chancellor and good friend, Dr. Shiv Kumar Sareen, Director Dr. Anil Agarwal, Chief Secretary Vijay Dev, Mrs. Manisha Saxena, distinguished invitee Dr. Kiran Mazumdar Shaw, whom we just heard a while ago, and it was a very interesting lecture. Distinguished invitee, Nobel laureate, Professor Harvey Alter, which we are to hear, and Shri Ravi Shankarji. Ladies and gentlemen, let me first begin by congratulating all members of this faculty, all the staff members, and particularly all students. On this 12th Foundation Day of the Institution of Liver and Biliary Sciences, a pioneer global university in the world, has successfully undertaken as many as 700 liver and 235 renal or kidney transplants. It has set up a genome sequencing laboratory for COVID-19 patients and established India's first plasma bank. My talk to you this afternoon has been elevated to the status of an oration, which is only because of Vice Chancellor Sareen's love and affection for the Narimans, particularly for my late wife Babsi, who was Shiv's patient and who he very fondly and most efficiently treated for many long years. Ladies and gentlemen, at the start of this program, Director Dr. Agarwal told us all that the Institute's strong focus is on this program. The Institute's strong focus, and I will focus on research. My audience today consists of competent, qualified surgeons, as well as students training to become qualified surgeons. Each and all of them are not just surgeons and surgeons in waiting. I look upon them as innovators as well. And my address to you this evening is to emphasize the importance of innovation in medical science, to inspire and stimulate in all of them a spark of invention. Let me first reproduce to you a message sent to us lawyers in India way back in the year 1985 by the then Secretary General of the Commonwealth, Sridhar Ramphal. The message read, and I quote, "I am urging you to wander into pastures beyond your domain. I ask you in return, by what superior law are its gates locked against you? I must remind you that we are all heirs to a noble tradition of intellectual inventiveness in response to changing needs." Unquote. This stirring up message applies not just to lawyers, it applies to doctors as well, because of what I'm about to tell you. Biological products of genetic engineering first became patentable in the United States in the year 1980, following a leading decision of the US Supreme Court. And it was an Indian-born microbiologist, Ananda Chakrabarty, who filed his first patent application relating to his invention for what is styled as human-made, genetically engineered bacteria capable of breaking down multiple components of crude oil, a capability possessed by no other naturally occurring bacteria. The US Patent Office rejected Chakrabarty's claim, ruling that since bacteria was living matter, it was just not patentable. Ultimately, the United States Supreme Court ruled by a narrow majority that it was. And this is now one of the world's leading judgments in patenting of human genes. Since Ananda Chakrabarty's case, a human cell line has become amenable to patent protection. For exclusive use has become endemic amongst members of the medical fraternity. All this is known, but what is less known is that amongst those who took advantage of this development 10 years after Ananda Chakrabarty's case, were a group of doctors at the medical center of the University of California. And it gave rise to a celebrated case that you need to know about and that deserves much wider publicity. It was of such significance, both to the legal and scientific community, that the entire Supreme Court of California, all 7 justices, sat to finally determine the questions raised. The facts of this case are interesting to lawyers and doctors alike. Unfortunately, fundamental conceptions of jurisprudence, which had been evolved centuries ago by Roman jurists, were not tested in their application, in this case, to modern technology. The facts are that in the year 1976, one John Moore underwent treatment for hairy cell leukemia at the medical center of the University of California. After hospitalizing Moore and withdrawing for testing extensive amounts of his blood, bone marrow, and other substances, the leading physician, Dr. Gold, and his colleagues who attended on Moore confirmed the diagnosis of leukemia and recommended that his spleen should be removed. If it was not, there was a danger to his life. The removal, they said, would slow down the progress of the disease, which it did. Moore signed a written consent authorizing the operation. Before the operation, Dr. Gold and his colleagues had, a fact then not known to John Moore, made arrangements to obtain Moore's spleen after its removal and take it to a separate research institution which had nothing to do with Moore's medical care, but had everything to do with forming a cell line, which, if and when patented, would be of great value. In fact, the value was estimated to be in the range not of millions of dollars, but billions of dollars. After the operation, and after more research on Moore's extracted spleen, the university applied in 1981 for a patent on this cell line, listing Dr. Gold and another doctor as the inventors for using the cell line to produce lymphokines, that is, proteins that help to regulate the body's immune system. As you all know, a cell line is a culture capable of reproducing itself indefinitely. Without informing Mr. Moore, and in pursuant of their research efforts, Gold and the university had continued to monitor Moore and take tissue samples following the removal of his spleen. A couple of years on, Moore, who was pretty bitter about a spleen being removed and having spent several years with doctors tinkering with him, discovered to his amazement that so small a part of his body, after being subjected to intense scientific research, was capable of generating $3 billion. He also thought it unfair that he should have no share in it. So Moore then sued the doctors and the university for invading what he called, or what his lawyers called, a legally protected interest of his own without his consent. John Moore had two causes of action. One, breach of fiduciary relationship between doctor and patient. And second, conversion, which in law meant converting Moore's body part, that is his spleen, for eventual profitable use by the doctors and the university. John Moore lost in the first court on both counts, but won in the Court of Appeal again on both counts. The university and Dr. Gould carried the case further to the highest court in the state of California. And the Supreme Court of California, sitting en banc means altogether all 7 judges, ultimately held that no law prohibited a physician from conducting research in the same area in which he practiced, but medical treatment decisions were made on the basis of proportionality, weighing the benefits to the patient against the risks to him. And a physician who added his own personal research interest to this balance could be tempted to order a scientifically useful procedure or test which offered marginal or no benefits to the patient. This was something a reasonable patient would want to know in deciding whether to consent to the proposed course of treatment. Hence, the need or necessity for a full disclosure by the doctor. The court therefore held that a physician who is seeking a patient's consent for a medical procedure in order to satisfy his fiduciary duty must obtain not just the patient's consent in general words, but the patient's informed consent. That is, by disclosing all personal interests unrelated to the patient's health, whether research or economic, that may affect his medical judgment. Since Dr. Gould and his colleague had concealed their economic and financial interest in the post-operative procedure, they and their patent assignees, the University of California, were held liable to pay damages to an action for breach of fiduciary duty. Also had the other more interesting cause of action, that of conversion. However, the majority of the state's highest court hesitated to uphold this plea. In the first place, it said, in no reported decision had any court imposed conversion liability for use of human cells in medical research, presumably on the ground that an item in your body is not property. Besides, the subject matter of the region's patent, that is the university's patent, that is the patented cell line, and the products derived from it, the court reasoned, could never be Moore's property because the patented cell line was both factually and legally different from the cells taken from Moore's body. They represented the product of human ingenuity, and that is why US federal law permitted patenting of such organisms. One more reason was given, a more important reason, for not extending conversion law into this area. And it was this: research on human cells plays a critical role in medical research, and researchers are increasingly able to isolate medically useful quantities through genetic engineering. However, one of the 7 judges of the court, Judge Mosk, with whom another judge also agreed, authored an impressive dissent. He expounded on the moral dimensions of the matter. Morality, he said, militates in favor of and not against recognition of John Moore's claim for conversion of his body tissue. Essentially, it was because of the defendant's moral shortcomings in this case, their duplicity, and what the judge called their greed, that the action had to be filed. Let the defendants be compelled, he said, to disgorge a portion of their ill-gotten gains to the uninformed individual John Moore, whose body was invaded, exploited, and without whom such profits as large as $3 billion would have simply not been possible. Judge Moore's colleague on the bench said that though they shared his sense of outrage, they could not follow his path. The question in the end was one of choices. The benchmark of wisdom for us as expositors of the law, the majority said, is the recognition that we cannot cure every ill, we cannot mediate every dispute, we cannot resolve every conundrum. And the majority of the court took refuge in that well-known dictum of a prominent judge of the US Supreme Court, Judge Brandeis, who had once famously said, the most important thing we do here, that means in the Supreme Court, is not doing. Where then should a complete resolution be found? The answer of the majority of judges was that a complete and just resolution was with the state legislature. That is, to create by law a licensing scheme which established a fixed rate of profit sharing between the researcher, inventor, and the subject. So Moore's claim was upheld only on the plea of fiduciary duty, but wholly rejected in the main and most important part of the cause of action for conversion of a part of his body. Besides, and to Moore's misfortune, his cancer had accelerated and he died soon after. So he could not even cash in on the first part of his claim. The majority of judges, if they had pondered a little and looked back, could well have derived assistance from Roman law. In Roman law, recognition was given to a legal concept known as specificato. When one person makes a new product out of materials belonging to another, who should be the owner of the new product? In Roman times, ancient Roman times, This doctrine had been confined largely to agricultural disputes, as for instance, where one person made wine from grapes belonging to another. The disagreement about the answer to the question as to who was the owner of the new product, the wine, led to celebrated disputes amongst great Roman jurists. There was something to be said for both sides. To support the claim of the maker alone was to give undue recognition to his labor. On the other hand, to prefer the sole claim of the owner of the original material, which were the grapes, was to place no value at all on the labor involved in transforming the material into wine. That's how the reasoning went. The disputes were not resolved in ancient Roman times. They were resolved much later in the time of Justinian, Emperor of Byzantine, in the 6th century. His legacy to posterity was the rewriting of Roman law, which is even today the basis of civil law in many modern states. Between them, they provided a structure, a map of the law, making it possible to locate a right or remedy in the larger scheme of things. Sir Henry Maine, who in 1847 became professor of civil law in Cambridge at the very young age of 24, identified the great benefit to be derived in the study of Roman law. It was instructive, as he put it, to clear up obscurity surrounding fundamental conceptions of jurisprudence. In the modern context, for grapes, substitute human cells. For wine, substitute the cell line. And there you get a new approach to a problem as old as the founding of Rome. In 1997, the then Regius Professor of Civil Law in Cambridge, Professor Johnston, published an article in the Cambridge Law Journal. And in it, he analyzed the fundamental question raised in the California court decision and said it had not been adequately answered. The professor reasoned backwards. If the university owned the patented cell line, it could have become an owner only in one of two ways. First, by transfer of title in the spleen and cells from More to the university, in which case we would have to assume that More acquired title to the cells at the latest when they were removed from him, in which event the basis of the transfer to the university would be a concept, again known only to Roman law, the concept of donatio, that is abandonment of his title. But this possibility would require further consideration of far-reaching ramifications, because it would give recognition to property interests in parts of the human body, which was extremely doubtful. Because according to the Lockean theory, that is the theory of John Locke, physician and philosopher, known as the father of liberalism, every man or woman owned his own body, her own body, not because it was his or her own property, but as God-given gift, and no person could deprive him of this. The professor then argued that there was another possibility, namely that the university might have acquired a new original title in a thing which had not previously existed, namely the cell line. And the new patented cell line was therefore a thing which did not previously exist, a possibility that again that was far too dogmatic, and besides it was certainly not equitable. So the professor discounted both the arguments because he was a justice-seeking lawyer. He preferred a modernized version, which he said was to be found in the German Civil Code. Under the German Civil Code, the maker of a new product becomes the owner when the value of the labor involved in creating it is not significantly less than the value of the original material. But then the maker is under obligation under the civil code to compensate based on the doctrine of unjustified enrichment. And so the maker of the cell line would have to account to the patient for some enrichment derived from the use of the patient's cell, not necessarily the whole of future profits to be made from the new thing. The essential point made by the Cambridge professor was that Roman law supplies a structure and a solution that can be resolved with, that modern problems can be resolved with old tools. And the value of the professor's analysis lies to a large extent not in the correctness of the results, but in its discipline and methodology. And above all, it is far more equitable than the California court decision in Moore's case. And the conclusion is, as to who owns the separated body part of a living human being remains a matter of controversy in the law. However, as the law, as it stands today, if something is removed from the body, that is spleen, liver, or kidney, and something new and important is added, such as a cell line, established from the removal of the body part, then the body part belongs to the inventor, not to the patient from whose body the part has been removed. But most importantly today, on the institution's foundation day, I think one should foster a spirit of inventiveness. There is never a stop to new invention in any field, at least not in medical science. And I request you all, surgeons and surgeons-to-be, to recall Sridhar Rampal's stirring words to lawyers that I mentioned at the beginning of this talk. Suitably amended, it would now read, "You men and women of medical science, you too are heirs to a noble tradition of intellectual inventiveness in response to changing needs." On inventiveness, there is a relevant poem that reads as follows, particularly with regard to a subsequent invention. And the poem reads thus: "Praise without and the go-ahead, praise without end the go-ahead zeal of whoever it was that invented the wheel, but never a word for the poor soul's sake that thought ahead and invented the brake." So it is all important for all of you who undertake transplant surgery to think ahead. There is no full stop to human ingenuity in every profession, particularly the medical. You have to keep innovating. God bless you and thank you very much.